والسلام على أشرف الأنبياء والمرسلين سيدنا محمد وعلى آله وصحبه أجمعين. Just to keep the floor the same, I'll speak in English for the benefit of my dear panelists and the audience as well. First of all, thank you very much, Dr. Mohammed, for the introduction, and also thank you to the SCCA for organizing such a great event and also for inviting me to be part of this great panel. Today, my presentation is going to focus on new trends in arbitration construction disputes. Before going to that topic, and I think it's prudent to just give a general outlook about the arbitration and construction disputes. And I think someone has to say that arbitration always remains to be the most popular methods of resolving disputes. And also another evidence or something to notice that arbitration centers such as the SCCA have grown around the globe. And these institutions and these venues have already or are now currently developing rules and regulations and standards to accommodate for new trends, to keep the momentum for making the arbitration as more favorable or preferred methods for resolving disputes. Some of these new trends probably going to be more focused into constructions, but some of them are general, but remain to be applicable to construction disputes. When talking about trends in construction disputes, and I think it's very important to touch on probably the same topic my colleague Aisha has touched on, which is FEDEC dispute resolution. FEDEC is a standard form of contracts that's commonly used in international construction projects, and it has an element and known for its way of resolving construction disputes. What is the new development that has happened in such principles? I think recently the FEDEC changed last year to seek to encourage dispute avoidance. The dispute avoidance by encouraging putting in place a dispute avoidance adjudication board, which is called the DAAB, at the outset of the contract, which means that all formal disputes should be referred to such office to try to resolve the disputes as a condition precedent to arbitration. And that, I think, it's a new development to encourage resolving disputes. End of the day, arbitration and any dispute resolution means the objective is to resolve, to reach to a resolve or settlement of such disputes. And by introducing this, is going to introduce kind of an efficient way rather than going to a full proceedings of arbitration, try to give such board the power to resolve the disputes before it goes to arbitration. Other new trend in arbitration, which is third-party funding. I appreciate that one of the speakers within this conference has touched upon this, but I think in my presentation is going to be a note to that principle. It's a new trend where allow a person who's not party to the disputes to participate and fund that case through arbitration. And this third party will have such relationship with the funded person on a commercial basis to have exposure to the commercial outcome of such case. This is not probably in some part of the world is not a new trend. It has started in Australia about 30 years, in Germany and UK 15 years, and US 10 years. However, just recently, it has started to become more commonly used in that. But it's fair to say, I'll talk about the policy driver for this. The policy driver for this is to allow and to give the opportunity for claimant to have access to or possibility to go and litigate or to arbitrate a case. Parties with difficulties, financial difficulties, will not have any limitation not to bring such case. So such trend will allow these parties who faces the financial difficulties to join with parties to come and litigate. The topic is probably going to be, or needs more maturity, and I think I haven't seen it here in this part of the world, and I think it's going to be very interesting to conduct further studies and discussions with jurisdictions who has experience in this, and how can bring the maturity between parties and the funding institutions, because one of the issues could be faced is how you can make the interest aligned. It could be the interest of the funders different from the funded person, which could potentially create problems. However, it's worth to elaborate or develop such concepts in order to achieve its policy driver. The other new trend, which is the summary dismissal and expedited procedures, is about allowing parties to make an early application before the arbitration proceeding take place. That's in the case if the case is lack of merits. Arbitration or any sort of dispute resolution, it takes time, it takes cost. Parties will incur a lot of costs. But this is also allow the parties to submit an application to the tribunal for a quick decisions to dismiss a claim if such claim lack of any merits. Number of arbitration institutions, they have such principles. I think the SIAC and the Stockholm Chamber of Commerce. The ICC, I just made elaboratory notes that its rules allow for such principles to allow for that. But not only that, the ICC also instituted for something called an expedited procedures, for which allow for any disputes of amount 2 million and below to have a quicker and simpler dispute resolution for simpler disputes. Those two principles remove or move towards simplifying and expediting and reducing the cost of arbitration. The last but not least, technology in arbitration. How to use technology. Technology can have different fronts when it comes to arbitration. And I think there's a move towards that. The clients always pushes counsels to be more efficient, to reduce cost, and I think there's a role of technology to play that. One of ways for the issue of evidence and documentation or disclosure of documents. Construction involves a lot of documents, voluminous and huge amount of documents, and going through and man work or man time to go through these documents and to look for evidence which means cost and time. Technological intelligence can play a role in terms of making analysis and produce quite a precise results through these technological means and tools. So in terms of evidence, collecting evidence, searching and making analysis of such evidence, this is also a mean to rely on. Also relates to construction technology. Sometimes sites can be very difficult for tribunal to go and look and view the sites and to have a look at what is the dispute in terms of standing on the sites. Drones can be used. We've seen it in a number of cases where the tribunal rely on and use such tool to use it for viewing construction sites when it becomes very difficult for a person to come and do that. Now, last but not least, in terms of the technology also online dispute resolution. That's also technology that allows parties, tribunal to convene for an arbitral hearings and proceedings through technology. That saves time for parties, saves time for tribunals, saves time also for witnesses, and also save costs. This is a few of new trends. I think because of the time, just wanted to concise them into these points. The takeaway or the conclusion, I think, is encourage institutions to accommodate, such as the CCA, to accommodate and to be flexible in terms of adopting for such new trends, to make it available to parties and councils, but also encourage practitioners, arbitrators, to use this and to tap into these new trends. Thank you.
Thank you very much.